but I'm delighted to have Alana Tiemessen present today. We've gotten to know her through this Transitional Justice Study Group, even though her base of operations is the University of Chicago. Alana got her BA at McGill University and her MA at the University of British Columbia, where she also got her PhD. And she's truly a scholar of transitional justice and has many areas of overlap. And do I recall correctly that you said that you were influenced early in your studies by Catherine King's work? Or
yeah, so I think any of us that are in the constructivist camp and also look at human rights norms and justice norms are very much influenced by that. Yeah.
So. And her topic today is of great interest to us. Of course, it's really the credibility of the International Criminal Court, and she's going to talk about the two mechanisms by which the prosecutions have become politicized.
Well, I'll try not to sound overly formal since we have a small audience today, but I do want to go through some of the, kind of the background to why I think this is an interesting way to look at the ICC and some of the case studies that I look at in this article as well. Just by way of background, as Charlie mentioned, I do kind of both transitional justice and the ICC. I started in my PhD with a broader project on transitional justice norms, trying to establish and explain that there are a consistent set of transitional justice norms at work across very diverse cases. So even though the violence is very different, even though the institutions and processes look different to us, there are a very consistent set of norms. And you can check back with me in about 2 years when that book is probably finally published, but that's a work in progress at the moment. So I took a bit of a segue then for the last couple of years to look more specifically at the International Criminal Court and as a good IR scholar about the politicization of the court as it's progressed through its first couple of cases. And I think for many human rights and transitional justice scholars, we see the ICC as a sign of moral and political progress in international politics and in the protection of human rights. And primarily its activities reflect this legal mandate it has to hold accountable people that it considers most responsible, so elite perpetrators of crimes like genocide, war crimes, and crimes against humanity. And as the speakers will probably be talking about on Monday, there's also this expectation, a more political expectation, that the ICC will be able to contribute to conflict resolution by preventing conflict, by deterring perpetrators of human rights abuses. So the ICC has really become part of this peacemaking toolbox, used alongside things like humanitarian intervention and sanctions as well. We've seen this with the combined use of judicial and military intervention in places like Libya. But I was really interested in looking at what affects the credibility of the ICC and also its legitimacy, particularly because it's been tainted by accusations of bias and by accusations of politicization, particularly because of the choices that it's made in terms of which conflicts to investigate and which individuals to prosecute within those particular conflict situations. So many contend that the ICC has not been independent and it has not been impartial of not only the interests of major powers that sit on the Security Council, but also of political elites in states that refer these conflict situations. So this is why I want to start today with this quote from Judith Sklar, that politics is regarded not only as something apart from law, but as inferior to law, that law aims at justice while politics looks only to expediency. The former is neutral and objective, the latter is the uncontrolled child of competing interests and ideologies.
Let me guess, she's a lawyer?
Known for her book, Legalism, Law, Morals, and Political Trials, which is of course more focused on the Nuremberg trials, but yes, very much so. And this maybe speaks a little bit to some of the interests that you were talking about earlier. So with the presentation that I'm doing today, I want to demonstrate how state behavior towards the court has politicized prosecutions, which I believe has negatively affected the credibility of the ICC as the impartial, independent institution that it was meant to be. So what I want to do is counter the pretense that the ICC's structure and its mandate somehow just immunizes it from politics and interference from outside actors. and using a relatively objective measure of impartiality, which is the degree to which the court holds both sides of a conflict accountable when there's been verifiable atrocities on both sides of the conflict. Now, advocates of international justice, in the ICC more specifically, make these normative and empirical claims that the court is and should be an apolitical institution. And tracing this kind of anti-politics or apolitical approach is something that I've spent a fair bit of time doing. They also claim that the court is on a kind of moral high ground to state politics and self-interested strategies in international politics. And these claims are usually supported by the fact that the court is guided by legal criteria of picking conflicts and cases, and also by its legal mandate and jurisdiction. But those among IR scholars, like Judith Sklar, challenge that this very pure form of legalism exists, arguing that law and politics are not entirely autonomous spheres, and that law can be used as a political instrument. And this is also something that some people have referred to as lawfare. This is the basis of another project that I'm working on, in which law can be used as a weapon of war, particularly by weak states. Now, this isn't really news to IR scholars, the fact that law can be used or abused as a political instrument. But what I want to look at with the ICC is how the ICC's politicization is actually quite different than what we've seen from past tribunals, particularly because its structure and its mandate is unique in that respect. And there are many things about its structure that actually invite politicization. So what I wanted to do with this project is look at whose interests are expressed through the ICC and how. How is it that these political interests actually affect the conflicts in the cases themselves? Now, if you look back to the Rome Statute negotiations, the founding document of the ICC, many of the debates were about the independence and impartiality of the court. And there was really two sides here. Weaker states, or smaller states, NGOs, civil society, did not want the ICC's authority tied to the United Nations Security Council, because that was one way of inviting politics into international justice. They wanted authority to rest with the chief prosecutor to pick cases and to pick conflict situations. Major powers wanted, obviously, the ICC's authority tied to the Security Council so they could control the court's mandate in its prosecutions and trials. So ultimately, the Rome Statute, as many of us know, reflects a compromise. First, the court has to select conflict situations, as they're called. This is a label that the court uses that's somewhat unique. That means a specific event or a conflict as opposed to a state as a whole. So the court can get conflict situations either through state party referral, upon the prosecutor's initiative if the conflict is in a state party, or through a UN Security Council referral for any conflict situation, regardless of whether it's in a state party or not. To date, half of the conflict situations have been self-referred by state parties themselves, and I think this is a significant piece of information, given that the other area of politicization of the ICCs that I won't talk about today, but we could talk about later, is whether or not there's an African bias in the court, and if the court is unnecessarily targeting African states. Given that half the cases were referred by the states themselves, I think that weakens a little bit that criticism that it's deliberately targeting Africa. Now, actually, selecting conflict situations is a bit beyond the scope of what I'm talking about today, but also something we can talk about in the Q&A. I think it's a very different set of dynamics that influences which conflicts are selected, and there's good legal reasons why the ICC has not pursued the conflicts of Sri Lanka, of North Korea, of Syria, simply because it doesn't have the jurisdiction to do so. I'm focusing more on which cases are being targeted, which individuals are prosecuted within those conflict situations. Selecting cases, individuals to prosecute within a situation is entirely at the prosecutor's discretion. His mandate is to pursue those people that are considered most responsible, so those elite perpetrators. In practice, this means government officials, warlords, military officials who are ultimately responsible for these crimes, even though they may not have blood on their hands. The chief prosecutor, particularly the past chief prosecutor Ocampo, has usually justified his decisions with this legal criterion of gravity. And this relates to the scale of the crimes, the nature of the crimes, the way that they are committed, but also their impact. So the ICC then is technically empowered with the ability to investigate the most serious situations and crimes, irrespective of how powerful those perpetrators might be. The former chief prosecutor's very apolitical rhetoric is quite notable in this regard. He's quoted as saying that the prosecutor's duty is to apply the law without bowing to political considerations. It is time for political actors to adjust to the law. We have no police and we have no army, but we have legitimacy, which I think is one of the most interesting quotes that I was able to snag from his many, many interesting quotes over the year. But I think this one carries a lot of weight in describing what he sees the mandate and the vision of the court being. Now, if we look at these patterns of politicization, first we have to look across all the different conflict situations. So far, the ICC has judicially intervened.
Can I ask you to back for just a second? I know that you said half of the referrals have been made by state parties themselves.
Yeah.
Of the other half, then, what percentage has been the prosecutor's discretion, and have there been any referred by the
Right.
Security Council?
I have a chart that's hard to read here. 2 have been sent by the Security Council, that's Libya and Sudan. Kenya is the only one initiated by the prosecutor as I counted. Technically in Cote d'Ivoire it was initiated by the prosecutor. I count it really as a de facto state referral because Cote d'Ivoire invited the court in, encouraged the court to intervene, but just because of the process that it was at in terms of statute ratification, it couldn't formally do the state referrals. The prosecutor had to start it. So for all political intents and purposes, it was a state referral. And that's always worth clarifying because it changes the count a little bit.
Exactly, and I'm very happy that Charlie asked this question because I want to go to this. I want to take time during your presentation, but I do want to talk about how state immunity from prosecution in pro primo to prosecutions, and all that's been really, I think, the most controversial thing on the ICC plate lately.
In terms of political leaders themselves not being prosecuted?
Or demanding not to be prosecuted
Oh,
as
yeah.
long as they're
Yeah.
sitting out of states.
Yeah, I'm definitely getting there. So that's a big part of this pattern of politicization, so within those conflict situations, the prosecution's strategy has been to target those most responsible. So this means leaders of rebel groups like the LRA from northern Uganda, a number of warlords in the Congo, and a few others in the other situations as well. Government ministers and military officials. There's been 2 government ministers from Sudan targeted, 4 in Kenya, former vice president from the Congo, Jean-Pierre Bemba, and 2 from Libya. Most controversially, of course, as you just alluded to, is the targeting of former or sitting heads of state, and the ICC has not shied away from these types of targets whatsoever. It has so far indicted Omar al-Bashir of Sudan, former president of Cote d'Ivoire, Laurent Gbagbo, the late Gaddafi of Libya, and of course now President Kenyatta of Kenya. So he will be the first sitting head of state to appear before the ICC and has done so kind of voluntarily so far. And I think, the ICC can be rightly commended for this type of prosecutorial strategy. This is exactly what the court was meant to do because it is ruling elites that are least likely to hold themselves accountable. If their own court systems and political systems don't permit it, you need an international court, the so-called court of last resort, to do so. But I'm arguing that these types of prosecutions have been politicized and imbalanced through 2 different mechanisms. And one is the way in which the conflict has been referred that you were just asking about, and then related to that, the prospect and degree of state cooperation that comes from that referral. So in the first mechanism, the nature of the referral, I'm arguing that referrals to the ICC by states parties to the Rome Statute and the Security Council result in one-sided prosecutions, particularly when these conflicts have verifiable atrocities on both sides. And these one-sided prosecutions are reflecting the political interests of elites and states that are referring the conflicts themselves. And this results in very dangerous impunity gaps. And this is not just a trope in IR. There's evidence to suggest that in many of these conflicts, it is this culture, this history of impunity that renews a cycle of violence. That violence also stems from a place of vengeance and of impunity from one side over the other. In instances of referrals from states parties, there's so far only been cases against individuals who politically and militarily threaten ruling elites, and leaving the crimes then of ruling elites unaccountable. In instances of Security Council referrals, the cases are limited to those that major powers, of course, feel are dispensable and undesirable. If we look at the one real case of a chief prosecutor's initiative to investigate, that is the only case in Kenya where we see prosecutions from both sides of the political divide and a real resistance to being politicized. And I think that even though it is just one case, we only have so many cases to work with the ICC, I think that's a significant departure from the other ones. The second mechanism is the promise of state cooperation, and this is where international politics and institutional politics really matters. So I'm really addressing what lies between the referrals and partial politicized justice. Parties who refer their conflict are signaling their willingness to cooperate with the court, and at least rhetorically, their commitment to human rights and their commitment to international justice. So this, undoubtedly curries favor with the international community and raises the prospect that the referring state will then cooperate once the prosecutor starts in with investigations and trials. So the ICC is, of course, encouraged referrals for this very pragmatic reason. It's also a means by which the ICC can ensure its own survival, because it needs winnable, doable cases. The same logic applies to Security Council referrals. Getting a referral from the Security Council means that it has more teeth, because they have a Chapter 7 resolution mandate with them, and it requires that all states are supposed to cooperate with that referral, although many times they don't, and of course there's no consequences for that. So the idea here was that linking the ICC with state referrals and the Security Council would give it this so-called mutual legitimacy push, that it would not only make the court more effective, but it would make the court more credible. And I'll give you an example from each of the different categories so that we can see how this has not happened at all. Now, I've mentioned there's lots of cases of state referral. I'll just talk a little bit about the Uganda situation in the Congo today, but we can talk about Côte d'Ivoire in the discussion or any of the other cases. As we know, in northern Uganda, the ICC has the mandate to really investigate any and all parties to the conflict that is between the government and the Lord's Resistance Army, or the LRA insurgency. Uganda self-referred this conflict in 2003. This was encouraged by the Chief Prosecutor's Office. It's not much of a secret that in the Uganda and the Congo case, the Prosecutor's Office encouraged behind the scenes for this to be a state party self-referral so that he wouldn't have to use his proprio motu or his prosecutor's initiative power. The former chief prosecutor and the Ugandan president later appeared in a joint press conference to announce the referral. This was a very poorly staged diplomatic maneuver because it was the first instance in which it looked like the ICC was just being enlisted into one side of the conflict, that even though it had the mandate to go after both sides, that it would just go after the LRA. The ICC later indicted 5 top LRA leaders for crimes against humanity, war crimes, that include killings, rape, use of child soldiers, among other types of atrocities. 3 of those indictees are still at large, including Joseph Kony, its leader, and 2 have since died. The prosecutor is not seriously investigated, nor have they indicted anyone from the Ugandan government in the military, even though the military in particular is known, especially among northern Uganda, for participating in what is very much a two-sided war, where the Ugandan military has targeted civilians if they suspect that they're allied with the LRA, has also used child soldiers, and most notably the crime of forced displacement on a mass scale. At one point, 90% of Acholis were living in IDP camps, allegedly for their protection, which made them more vulnerable to attack from the LRA. All of these crimes are considered to be atrocities by most people's measures of atrocities. The Ugandan government has repeatedly threatened to withdraw cooperation if it is targeted for prosecutions. So it's really had a strategic benefit of bringing in the ICC. Not only did it bring more attention to the conflict at the time, but it de facto sanctioned the Ugandan government's crimes. If the ICC is not willing to investigate, and indict people, it is less likely that this will happen at the domestic level. And this is a similar dynamic that we're seeing in Côte d'Ivoire. To justify this strategy, the former prosecutor continued to argue that LRA crimes were relatively more grave, using this gravity criterion, than the Ugandan military's crimes. Nonetheless, while that may be the case, that the crimes by the LRA are more serious and are on a larger scale, research by human rights organizations, civil society on the ground in northern Uganda have shown that the victims there see this as a two-sided war, and they're therefore demanding accountability for crimes committed against them by those actors as well. So in this case, we're seeing the first instance where ruling elites in states that are referring their conflicts can ensure their impunity so long as their crimes are no graver than their opponent's crimes. We see a similar dynamic then in the Congo. The Congo also referred its situation to the ICC shortly after Uganda in 2004, hoping that the court would deter and remove dangerous warlords that were operating in the eastern regions. They were targeting civilians, contributing to mass displacement and rapes, and of course pillaging resources. 5 warlords have since been indicted by the ICC. Of course, many of us know about the first completed and successful conviction of Thomas Lubanga, who's the picture in the bottom there. There's also been a second conviction, although a much weaker one, of Germain Katanga, and that was just recently. There's also been an acquittal. Bosco Ntaganda in the top picture there, this is as close to Law and Order drama as we get at the ICC, but when he surprisingly surrendered and requested that he be transferred to the court, this is a case that is awaiting trial at the moment. So the court, established some pretty significant precedences with this case, with this situation, because there's been multiple arrests and 2 successful trials and convictions at this point. But the prosecutorial strategy is similar to Uganda in that it's very much partial in favor of ruling elites. So far, there have been no charges for crimes committed by the DRC military, a military that is notorious for targeting civilians, for mass sexual violence, and to a lesser degree for pillaging resources. So President Kabila has really gained a political advantage here because all of the people that the ICC has targeted are not only military rivals of the government, but they're political rivals of the government as well. These are not warlords that are content to just be warlords. They are warlords with political ambitions that have authority and have some form of odd governance in the eastern regions, and this is very much a threat to President Kabila's rule. There's also concern that the ICC has not targeted other regional governments for their crimes in the Congo, especially Uganda and Rwanda, who have sponsored and proxied rebel groups in the region, and their crimes have remained uninvestigated and untouched by the ICC. The best example of how the Congolese government has selectively cooperated with the court is with the case of Bosco Ntaganda. When Ntaganda was indicted, he was still a warlord in the eastern regions. Shortly after that, in 2009, he allied with the government, was given a prestigious post in the Congolese military. Once that happened, the Congolese government was protecting him from the ICC, refused to transfer him, and for many years everybody knew where Ntaganda was. It was not simply the case that we couldn't find him or couldn't arrest him. It is not like with the LRA. It was very easy to find. It was just that Congolese authorities were unwilling to arrest and transfer him. Once he defected from the military in 2012, then he was on the outs with Kabila, and Kabila announced his intention to arrest Ntaganda, but shunning the ICC, insisted that he be tried in the Congo. When he surrendered last year and turned himself into the U.S. Embassy in Kigali in Rwanda, it is likely because he has had a falling out both with the Congolese government and with the Rwandan government. So it is really only in the interest of these 2 actors to transfer them to the ICC when it's in their interest militarily to do so. Now, turning to one case of Security Council referral, there's 2 cases here. There's Sudan and Libya. I'll just talk about Libya, just in the interest of time and to cut down a little bit on all the detail. The Security Council and the court have an interesting relationship. It's one that's evolving, particularly as the U.S. has struck a more cooperative, engaging relationship with the ICC in some respects, but it's also very inconsistent. particularly as we've seen between the Sudan and the Libya referrals. And as I was mentioning to someone earlier, there's a great new book by David Bosco called Rough Justice that is about the ICC's relationship with major powers and the Security Council more generally, and details all the kind of the stuff, the goings on in the background of that.
And Alana, would it be fair to say, for those who may not have tracked the history of it, that the U.S. did everything in its power, including threatening military assistance to about 80 countries if they voted in favor of the Rome Statute? So we were totally antagonistic to the idea of the court.
Very much so. Under Bush, and particularly under John Bolton's leadership at the United Nations, not only was there an attempt to disenfranchise the court, but kind of undermine it and keep it from functioning by enforcing these agreements with other countries where that unless they promised not to take Americans to the ICC, they would have aid withheld. There was also the infamous Invade the Hague Act, whereby if any Americans were imprisoned at The Hague, then U.S. forces were authorized to invade and remove them. I think that act is no longer in existence. I'm not actually sure. So there's all sorts of things to undermine the court. So it was a really big deal when, in the case of Libya, that the U.S. and China actually voted for this referral. They didn't just abstain, they voted for it. And I still remember Ocampo's news conference that he was just giddy with excitement that they had voted for it. And maybe this was the promise of a better relationship with the Security Council. So the relationship between the court and the council then is evolving, but it's inconsistent. As I mentioned, the Security Council can empower the court by referring any conflict situation there. It does not then, it's important to note, pay for that prosecution or contribute financially in any way to the ICC's cases there. But it is a kind of boon to the ICC because states are obligated to cooperate with the arrest warrants that follow. So skipping ahead over Sudan and over to Libya, the Security Council referred this conflict situation because of Gaddafi's crackdown on protesters and civilians, and then the ensuing kind of civil war after that, referred it in Resolution 1970 to the ICC alongside imposing sanctions and other military endeavors against Libya. So it was very much a combined military and judicial intervention that was authorized by the Security Council. To the detriment, though, of the ICC's independence and also its impartiality, the resolution's language limited what the ICC could do in Libya. I didn't put it up here, but it limited first in terms of its temporal mandate. It was only allowed to investigate a very short period of time in the Libyan conflict. It also limited the prosecutor in terms of who he could target. He could only target Libyans. Non-Libyans would be subject only to their national courts, could not be subject to the ICC. So this took off the table the option to investigate mercenaries that had been involved in Libya, and of course especially NATO forces as well. So while the referral was encouraged and lauded for a lot of reasons, the limits on the court is not something that it was expecting.
And were those limits like purposeful or ignorant?
Purposeful.
I can imagine both, so.
Purposeful.
Okay.
What there was debate about among legal scholars was whether or not the ICC had to listen to the Security Council with respect to those limits.
So the limits emanated from the Security Council.
They did, yeah. The referring resolution put limits, and because, the court's still relatively new and we're working these things out, they're working these things out, it wasn't really known if the Security Council could do that.
Right.
The legal interpretation was that if the Security Council refers a conflict, the ICC can investigate anybody within that conflict
Right.
situation.
Like, here's the situation, and then it's up to the ICC
Exactly,
to sort of suss
exactly.
out what's going on. Okay.
The other concern or question from a legal perspective was if there's a conflict referred by the Security Council, can the ICC simply say no? And I think the consensus was that it can. If the ICC determines that the conflict is not serious enough for it to investigate or not on that meet that gravity threshold, it can say no after an investigation. So they're still working out these kinks in this relationship, if you want to call it that, between the council and the court. And actually the politicization of this particular case extends further because there was a UN Human Rights Council report that said that crimes were committed by both sides in the Libyan conflict, just as we're seeing now in Syria, that rebel forces were also committing war crimes and crimes against humanity. But predictably, the prosecutions only targeted Gaddafi's regime, targeted Gaddafi himself, his son, Saif Gaddafi, and then the former intelligence minister, al-Senussi. And there's been a lot of political fallout. This case is, in some ways, a big failure for the ICC. Libyan authorities since then have refused to transfer Saif Gaddafi and al-Senussi, and the ICC has relented, I think, at least on Senussi, saying that it won't request his transfer anymore, that they'll let the Libyan authorities prosecute him.
But if I can just add something, part of the reason why Libyan authorities have refused to transfer the prisoners is because, at least as far as Saif Gaddafi is concerned, they themselves don't have the prisoner in their hands. It's not in their custody. It's still,
He's still being held in a different region by rebels, right?
Yes, he's being held in Int'l, in the eastern part of Libya.
Yeah, so...
just very briefly, there's been a very interesting development recently where the Libyan authorities are now starting prosecution of 30 defendants altogether. We had a session talking with one presenter a few weeks ago, and the Libyan authorities said that although they do not have Saif in custody, they will still be able to try him via Skype.
Oh, via Skype, right.
And I think you can imagine where that is coming from, but we can discuss that.
Yeah. Skype is a new way to do prosecutions these days because both Deputy President Ruto in Kenya and President Kenyatta are also allowed to video conference into some of their hearings because they have other stuff to do. So, modern technology, I guess. So this has, this case has produced all sorts of political problems for the court, one of which is trying to get the accused transfers, which is kind of given up on. The Security Council has completely backed away from enforcing the referral, as it kind of did in Sudan as well. It referred the cases, but then didn't give any teeth to actually do arrests or transfers or anything like that. It's also created problems with the African Union because the African Union opposed the arrest warrants and did not want its member states executing these arrests. And I think the other problem, too, is this combined use of military and judicial intervention, because it's very clearly politicized what the court is doing. Even though it seems like a positive sign for peacemaking and conflict resolution, it invites politicization into the ICC by linking the council and the court so closely together. And it's not that they're even really very well coordinated, since there wasn't a consensus on whether or not the military forces intervening would be arresting these individuals and transferring them to The Hague. So it's not a coordinated approach. The last case, then, is one of prosecutorial independence, and that's with the case of Kenya, which in many ways I think is one of the most interesting cases for the ICC. Not only because it's so different than the others, but the way domestic politics in Kenya has unfolded with this particular case, because it's become a real issue for domestic politics, particularly in the last election, presidential election in 2013.
And Alana, can I clarify, because I actually led a human rights mission into Kenya in January when some of the violence was still going on following the elections. And it's not clear in my mind if Kenyatta was indicted before he was elected. I thought he was, so that he actually became president after he was indicted by the court. Is that
yes,
correct?
Yeah. So the indictments came in 2010 or 11. And I'm not sure if it was before. I think that may have been before he announced his candidacy to run. But the election then was in 2013.
And he actually ran part of his campaign stating that if he ever was elected, he would cooperate with the court.
Yeah. They have a very, well, and I'll get into this, but it's a very mixed record of cooperation and compliance, because on the one hand, they've been very anti-ICC, this is a violation of our sovereignty, on the other hand, publicly pledging that he'll cooperate. And in the Kenyan presidential debate as well, when asked about his ICC status, he described it as a personal problem that he would work on. So, there you go. So in 2010, former prosecutor Ocampo opened investigations into the conflict situation, which was the period of post-election violence around the 2007 presidential election. Kenya was given many years to do justice on their own terms, in their own courts and through their own institutions, and failed to do so. As part of the peacekeeping agreement, or peacemaking agreement that was negotiated by Kofi Annan, there was a promise, and also by their own Human Rights Commission, that if they didn't do justice on their own terms, they would turn over the sealed list of perpetrators to the ICC, and that's exactly what happened. The ICC then issued summons, not arrest warrants, for 6 political elites, 4 officials, or 5 officials really, and 1 radio broadcaster. This is the first instance in which charges have been brought against individuals on both sides of the conflict. 3 on each side, at least based on the divisions of the 2007 election. And this is also the first case in which the court has been able to resist the political interference from Kenyan elites and gone ahead with the cases despite the opposition and all the attempted interference. So a very preliminary, cautious conclusion is that there might be some benefit to cases that the prosecutor initiates on his own accord, where it doesn't come from a state referral, and they're able to kind of buck those threats of non-cooperation. And the ICC has remained free of politicization in a couple of different respects. The individuals that have been targeted are all top officials in the government, and of course now one is President Kenyatta, the other is Deputy President Ruto. And while this poses a lot of different kind of bureaucratic and legal problems that we can talk about, that's not really about politicization per se, it is true to the ICC's mandate then that it will prosecute anybody, even sitting heads of state, irrespective of how powerful they are. The indictees are also on both sides of the political divide, or at least they were in 2007. Very interestingly, in the middle right pictures there, Kenyatta and Ruto were on opposite sides in 2007. They formed an alliance to win the 2013 election. The main benefit of doing so is that it brought their 2 different ethnic constituencies together. So that's really what helped to get them elected. But they also kind of had what even they termed an anti-ICC alliance. We'll cooperate with the court, but we also think that this is an infringement on Kenyan sovereignty, it's judicial colonialism. Kenyatta agreed that it's race hunting by the ICC and made a very powerful speech to the African Union in that respect.
You said race?
Race hunting.
Hunting.
It was either I think it was the Ethiopian president that said that with the ICC, and Kenyatta said he wouldn't disagree with that. Yeah.
That's part of what they call for mass withdrawal of the African Union,
Yeah,
from
exactly.
the Rome Statute.
And that was in that speech, that was that event that he was speaking at. So yeah, and they've remained resistant to, the Kenyan government and political elites have done a lot of political and legal maneuvers to get the cases dismissed or try and undermine them, even though rhetorically they say that they'll cooperate with the court. They won't turn over the financial records of Kenyatta because the prosecutor thinks it will show how he organized and sanctioned some of the violence. They've been intimidating, bribing witnesses. The cases of several others, especially Mutara on the bottom right picture there, was dropped because of that witness intimidation and bribery, and it's threatening to undermine the Kenyatta case as well. They've sought a mass withdrawal of African states through the African Union, which did not go through, but the AU did pass a resolution that said that they don't want the ICC prosecuting heads of state, which is ironic because that's exactly what it's supposed to do in some cases.
And if I can only add a couple of points in this, recently there's been the top Assembly of State Parties in November, this past November in The Hague, and that's the legislative body of the ICC. And the entire discussion at the ASP was revolving around the issue of prosecuting sitting head of states, and they eventually came to a compromise that says that it doesn't have to prosecute, and that for some of the hearings they're excused and they can be Skyped in.
Yeah, and I think it's an interesting question for the ICC to grapple with, because on the one hand, if the ICC doesn't prosecute them, nobody's going to until they're deposed, right? Just like what would happen with Charles Taylor in Sierra Leone and Liberia. On the other hand, is it worth the trade-off? Because now the African Union is almost as a whole, with the exception of a few small states, opposed to the ICC. And the ICC needs their cooperation. It needs their cooperation to access witnesses, testimony, and to execute arrest warrants. So it's an interesting question for court officials to ask whether it's worth it to pursue state officials. And I think it's something that the human rights community has to grapple with more broadly. And then the political elites in Kenya have also tried to get the case dismissed at the ICC on legal grounds, saying that Kenyan courts could do this on their own at this point. They have a new constitution and they've done a number of rule of law reforms. but the ICC says that they're not up to snuff. All of those efforts have failed, and so far the ICC is still pursuing those cases, and I think that's a positive sign for its credibility and for its impartiality.
And is the implication there that this required the consent of the new prosecutor, that she decided, yes, we'll continue these?
I think so. I think the change in prosecutor is significant because she has a very different tact and approach to dealing with state relations, political elite relations, in the sense that she's pulled back. Ocampo has very much played the role of a diplomat and a politician for the court. And while it helped the court in some respects, it didn't help the court in some respects because it really rubbed people the wrong way. And the prosecutor, Bensouda, the new prosecutor, has been quite driven to continue the Kenya cases despite all of this pressure. And she's done a few outreach activities in Kenya as well. I'm not sure how well that went over, but I mean, the African Union is already calling her a traitor, so she's made her enemies already, but that was expected, I think, for the most part. So yeah, just to sum up here, I think this is one way to test the impartiality, independence of the court, is the degree to which it prosecutes both sides of a conflict when there are crimes on both sides. And really, I don't think that's subjective. There's plenty of evidence to suggest that the Ugandan military, that the Congolese military have committed atrocities. To say that they are less grave than their opponents doesn't change the fact that there are people victimized by those crimes, and this could contribute to a resurgence of violence. The mandate of the court and the way that it encourages referrals is part of the problem, I believe, and this was something that, ironically, in the Rome negotiations, they thought would empower the court, and I believe that the opposite has happened. One way to get around this, and to maybe help sure the ICC's survival, does depend on empowering the prosecutor. This is a tough sell, particularly because major powers were always concerned that a rogue prosecutor would go after the U.S. or other major powers. I don't really envision a world in which a rogue prosecutor has that much power, because the court is constrained in its jurisdiction. But nonetheless, there's reasons for institutional constraints on individuals, so it would be a tough sell, but I think it's one way to ensure the impartiality of the court going forward in future cases. If you want more detail on some of the other cases, this is coming out as an article in the International Journal of Human Rights sometime in the next couple of months. So that goes into the Côte d'Ivoire and Sudan cases as well, so that I didn't have time for today. So yeah, I'm happy to talk about any of these political problems as related to the ICC, so whatever you guys got.
Thank you very much. I will add as an aside that this fear of the rogue prosecutor is a recurring nightmare
Yes.
of the U.S. So in the 1990s, Belgium passed a set of statutes that said if plaintiffs brought evidence of crimes against humanity or war crimes to these three judge tribunals, they would act as kind of a I guess you would say like a grand jury, and decide if there was sufficient evidence to merit a case, and if so, the case could go forward. So the survivors of the Sabra and Shatila massacres in Lebanon, when the commander of the Israeli forces pulled back from surrounding these two refugee camps, let the phalanges in, and they slaughtered about 10,000 civilians in a day or two. The Israeli commander was actually sanctioned by the Israeli military and dismissed from the military for neglecting his responsibility to civilians. And then he went on with his life and nothing happened. But 10 years later in Belgium, the survivors of some of those massacres took the evidence from that Israeli military court and brought it to Belgium and said he should be prosecuted. The general was Ariel Sharon, but by now he was sitting prime minister. So the courts in Belgium actually said it looked like there was sufficient evidence to warrant a prosecution, but they said we're going to set this aside till he steps down. But that provoked in the U.S. this huge fear. So we threatened to move NATO headquarters from Belgium, which would have cost them about $5 billion a year if they didn't pass an additional statute exempting any U.S. personnel from ever appearing before those tribunals. So similar to the Hague.
Well, and even the former prosecutor of the ICTY and the ICTR, Goldstone, has, rubbed people the wrong way over the years, particularly with the Goldstone report and what. So there's some precedent for prosecutors upsetting the major powers. And there was a bit of contention that went into picking the ICC prosecutor. Ocampo they thought would be very neutral. He had the background in the Argentinian junta trials and whatnot, so he seemed like kind of a safe bet, whereas a lot of other people were eliminated primarily because the major powers would oppose them. But I guess they may have bet wrong a little bit in that situation. So.
Goldstone revised that original decision. I had a question about the makeup of the court, the structure of the court. How many people are there? What I assume they're justices, prosecutors, investigators, all encompassed in the ICC.
Mm-hmm.
What is the size of it, and how are they appointed?
Well, the judges and whatnot, prosecutors are appointed by the Assembly of State Parties. Federica, you may have some stuff to add here as well. The Assembly of State Parties, so all the countries that are party to the Rome Statute have a representative in the Assembly, so it's kind of like a parliament. And they pick the judges, and the judges rotate over a period of a couple of years. And there's some geographic diversity in how they're represented and all that kind of stuff. In terms of actual numbers, I don't have the numbers on the judges, but the prosecutor's office is quite large. It's a large team, and there's a deputy prosecutor's office as well.
I don't have any numbers either, but I think it's interesting that the original pool of candidates is actually selected by their home countries, and that they're sent to the Assembly of State Parties for approval. Mm-hmm. And just last year, I think a Canadian deputy prosecutor was chosen.
Yeah, and there's a lot of the states party to their own statute really want their judges sitting at the ICC and want their prosecutors. That book that I mentioned before, Rough Justice, has a lot of detail about the extent to which, states are involved in diplomacy and wrangling to get their people on the court and to get them represented, and even the extent to which the United States goes behind the scenes to try and influence these things, even though it technically does not have a say. But to make sure that they get the people that are favorable to them, even beyond the prosecutor.
And these dynamics become very, very clear if you ever attend one of these assemblies of state parties that gather every year to discuss major issues in ICC plates, but also amendments to the original statute. And I attended not the one from last year, but the 11th Assembly of State Parties. It was also in The Hague, and it was just plain clear how these background dynamics will work.
Yeah.
Bias is pretty much built into that whole system by the way it's structured, it seems to me.
A bit, but there is some effort to make sure that there's geographic equality, representation, I'm not sure the right word is, across the judges' panels within the prosecutor's office, so that no one region or state can control the court in that respect. And also to make sure that developing countries and African countries are represented as well, because many, many African states are party to the Rome Statute, so they have to be represented as well.
And that's also something that normally should come up whenever there are accusations of ICC targeting Africa or being biased towards Africa. This is something that doesn't come up very often, but because of this geographical necessity of distribution, a lot of the ICC staff, so the people that are actually paid by the ICC, they are from African countries, and this does not come up.
And the new prosecutor is from the Gambia, and and at first when she was initially elected, there was all this coverage saying, well, things should be fine now with relations with African states. It's a little ridiculous to just suggest that just because she's African that all the states are going to do whatever she tells them to. It's clearly not the case. But it is significant in terms of combating a bit of this question of African bias, because she's very much operates under the assumption that the court is there for victims, and she wants to see a more victim-centric court than what the previous prosecutor had been, which was a much more perpetrator-oriented court. He wanted the big fish for the notoriety, or Bensouda's more focusing on what's most important for justice for victims. So she has a different perspective in that sense.
And I'll give you an example of that someone pointed out to me. One of the prosecutors of the hybrid court in Cambodia came through here about 6 months ago. He was a British barrister, I guess is the title. And he said that to date, in Cambodia, they had bussed in about 150,000 Cambodians to watch some segment of the trials. And when you compare that to the trial of, that took place in The Hague of one of the African warlords, actually nobody from his country, virtually no one was able to kind of participate in that. So in terms of I think the idea in Cambodia was allow the victims to kind of be witnesses to the trials. And in Ocampo's case, there was kind of nobody in The Hague at the trial.
And what's interesting about those two examples, too, is that in Cambodia, despite, that is a very politicized court. The judges are very much controlled by the Cambodian government, and there's lots of political interference, but the court has been successful in terms of victim outreach, partly because it's located in Phnom Penh, so it's easier for victims to get there, of course, but there are these specific programs set up so that victims can view the trials. Victims are allowed to be represented as civil parties or something like that in the trial. I'm not sure if I'm using the right word there, but so they have some stake in the process. And if you look at the Thomas Lubanga trial at the ICC, I was told, and I don't know if this is for sure, but they didn't even broadcast the verdict in his community where he was from. So the people that were living there didn't even have access to that, the most important moment of a very, very long trial. And the ICC has been heavily criticized for its failed outreach strategies.
I guess it really depends who you ask. It is true that there's a lot of criticism for the ICC, but it's also true that I have read different reports, and I've also seen different images, so if the pictures up there, of people gathering, a lot of people gathering in the same room watching ICC proceedings, and this was specifically, Lubanga was on screen, so it was
Human
the same
Rights Watch
thing.
has a report with that picture on it too,
and so I guess it really depends who you ask in terms of what the outreach effort was, but it is true definitely that there's a long way to come, and that the new prosecutor is moving forward in that direction. She has also changed the prosecutorial strategy consistently to make it become more victim-centered, and part of it is, and that stems directly from the Lubanga case. She wants to focus very much on sex and gender crimes because when Lubanga, and that's where I think you can really see the difference between the two prosecutors. When Lubanga was brought before the court, Moreno Ocampo wanted to start the prosecutions very quickly, and he wanted to get going with the trials, and he didn't have enough evidence to tie the sex crimes that have been perpetrated specifically to this defendant. So those charges were not included in the indictment, as opposed to what Fatou Bensouda is doing now, which is she released a statement, and that is one of the major priorities of her prosecution strategy.
Is the goal of this kind of research, it seems like very, very important research, is the goal to make recommendations for change, or is there anybody that would listen to that? How can we make it better? Is there any thought of that when you, there must be thoughts of it when you're doing the research?
Yeah, there is obviously a normative side to what I'm arguing here, that I'm saying that there should be certain changes that the court needs to make. It's not, in that sense, a completely, I don't know if the right word, objective, typical scholarly approach to this. But I think anybody that studies transitional justice, human rights, the ICC, are also advocates for these issues, and we can't really pretend that we're not advocates. As scholars, we're supposed to be neutral. We can engage in neutral, objective scholarship, but you don't do this unless you're advocating for impartial justice and human rights, right? So, whether or not these types of findings help in any way depends on a lot. People outside academia do not read academic journals, unfortunately, but there's other ways to communicate our views through blogging, through Twitter, through public presentations and whatnot. And I think the international justice scholarship community has done a pretty good job of putting their views out there in forums that people that have more impact on these institutions can actually read and use. But, you know, nobody's given me a call yet, if that's what you're asking, so.
Oh, it's forthcoming, so.
Yeah, we'll see, so.
So actually related to the point you just made, I'm wondering how much evidence plays a role in this. So I'm thinking if you're the state that invites the ICC in, you'd be like, well, here's all the evidence
Right.
against the other side. And they're probably not like, and also here's all the evidence against us. So is that all an issue? And then I hadn't thought about sort of the speed of prosecution and how that would also limit sort of the evidence you had on hand.
Well, there's not really a limit for when to start prosecutions. So there's not a limit between when the indictment is issued and when you have to start prosecution. The time that you have in between is really the time that you need to, whatever time it takes to gather the evidence. That would support the indictment, though. That's, if the indictment is there, there needs to be evidence in the first place.
Right.
The speed that I was talking about is the fact that this was the first case, and that the court had been kind of dormant for a little bit. So I just want to, I guess, give a clear sign that the court was functioning, wanted to start, make it into work, but.
Right.
And in one of the documentaries on the ICC, the prosecutor's there on screen saying, we wanted to move quickly. We needed to show that we'd be relevant, so we started welcoming and inviting referrals.
Right. So so you don't think it's an evidence issue?
There is an evidence issue. Or
are they just going with what they have? You know what I mean? Like, let's go with the cases. If we want to establish that we're doing something, we're going to do the cases that seem most serious and/or that we have the most evidence.
So they get evidence from the states themselves. The Ugandan government has given them loads of evidence on the LRA, of course, and there's no shortage of that anyways. And so they do get evidence directly from the government. So of course that's going to limit it's going to affect bias to a certain extent.
Right.
But they also do their own investigations if they're allowed into the country. They don't just rely on what's given from governments. So they've done their own investigations in Kenya, in Congo, in Uganda. They have not been allowed in Sudan, of course. So they are reliant on interviewing refugees that cross over the border to Chad. So it is dependent on a degree of state cooperation, but of course they do independent investigations.
Right, and so in all these cases they certainly could have.
They could have,
prosecuted the other side.
Yeah.
But another problem with evidence is the fact that, there's a lot of documentation that these atrocities are taking place, but what is relevant for the court is the ability that you're going to have to tie a specific message or to a specific person, and that's where the big problems come in, because as Alana said earlier, these perpetrators make sure that their hands are clean, and so a lot of these trials have relied on witness evidence, and that's why there's been a lot of witness tampering, and that's also created a lot of problems because a couple of cases have been dropped. The fact that the principal witness, it turned out to be unreliable, and so they had to drop the charges.
And even when cases weren't dropped, people have been indicted for the weaker of their crimes. Like in the recent Jermaine Katanga case, he was indicted for the weakest part of his charges, not for the most serious crimes, because they can't prove chain of command with the type of evidence that they have. So it's interesting, too, when I teach this to my students, they're like, well, these are such notorious perpetrators. Of course they're guilty, and of course they're going to be convicted. But it's actually really difficult to prove that they are at the top of the food chain. And some of them have blood on their hands, like the warlords, but the government officials don't. And, so they're quite careful, especially knowing now that the ICC exists, they are going to make sure that the paper trail on that chain of command doesn't exist. So,
Well, Alana, I don't know. Oh, no, go ahead.
I wanted to ask a slightly different topic, but sort of what influences the decisions between having the country-specific tribunals, having the trials at the Hague. I know that there's been a shift towards doing it at the Hague nowadays, and also the idea of truth commissions and how does politics play into that decision being made. So I don't really know a lot about this.
Yeah, actually, in a way, the shift is. It's easy to look at this field and say the shift is towards international justice, but I actually see it the other way around, because the ICC is a court of last resort, right? It's no longer considered ideal to have international prosecutions. Ideally, we want courts to have good enough rule of law and capacity to do it themselves. And early on, Ocampo said this weird thing where, one sign of success for the ICC was that he would do himself out of the job. and that he wouldn't be needed anymore, which is not really true. But now the ideal is to have it locally. So because the court is a court of last resort, it has to make sure first that domestic courts can't do it. And so that's why there's all this pressure in Kenya to see if they can do that domestically as well. But on the other hand, there's a bit of tribunal fatigue in the international community about setting up separate tribunals for separate conflicts when they're necessary. There's still a hybrid court for Lebanon, but it's just dealing with one incident. The hybrid court for Cambodia is still ongoing. But other than that, like, there's not a lot of other international tribunals. But it's possible also to have multiple institutions operating at the same time, to have a truth commission at the local level and the ICC prosecuting cases, because they're dealing with different types of perpetrators and all that stuff. So it's no longer just like, oh, do we have an international court or a truth commission or a hybrid court? A lot of times it's kind of this big messy mix of everything at the same time.
What is sort of like chosen?
That's a good
And
question.
like how does the politics international?
Yeah, I have a long PhD dissertation that can answer that for you. So part of it is the nature of the violence itself, I would say. So that can help determine what type of justice is needed. Because we saw different responses, like in the Latin America cases, where the violence was torture, disappearances, not the kind of mass killings you saw in, say, Rwanda or Cambodia. So sometimes that can affect the nature of the response. So we saw more truth commissions in Latin America. The violence was so abhorrent and on such a scale in Cambodia and Rwanda that it would seem like only an international tribunal, something that's a really big deal, something like that would be necessary. So partly the type of violence, it's partly whether or not domestic courts are capable of doing it, so there's a capacity assessment involved. And then honestly, there's the realpolitik of, is the international community interested enough to set up a court for a particular conflict? You know, Sri Lanka is a good example. If that's a case of a massive impunity gap where there's been no accountability really whatsoever, at least not genuine, does the international community have the will to press Sri Lanka for a tribunal? The Human Rights Council does, but no other state really does. So political will at the international level also affects, I think, what gets set up.
And Alana, how much do you think also is there a kind of a filter through which, if we tried this guy in The Hague, this is a bunch of white people trying an African, versus a hybrid tribunal like in Sierra Leone, where there were a couple of white judges on that, but it was really an African hybrid court. Is that something that you think kind of filters in there someplace?
I think it does. So it's usually not framed in terms of, you know, a racial, geographic, or global racial divide. They usually use the much nicer language of local ownership, right? So, just so common in peace building speak. But it's the same idea, really, so that people are judged and tried by their own people according to their own cultures and their own traditions, and also to help build their own rule of law. And that was a huge justification for the Cambodia, Sierra Leone, and Timor tribunals. It is in part why I think the ICC tries to have better outreach and better representation for the judges and the prosecutors as well. But because it's located in The Hague, and that doesn't help those perceptions. There have been suggestions in the past that the ICC do in situ trials. That was maybe suggested for Libya. Like maybe the ICC can be a mobile court of sorts, and kind of help lead a trial at the local level to involve more local officials.
Washington, D.C.?
Yeah, no. Oh, that would be interesting.
Or Kissinger?
Yeah, I'm sure he'd participate voluntarily. Yeah.
He'd have to Skype in, he's busy.
Yeah. So, I mean, I think there's possibilities for that, but the ICC doesn't really have the capacity to do it at the moment, and I'm sure there'd also be security concerns and all that kind of stuff.
I think a lot of it is also funding related, because these prosecutions are really, really, really expensive.
Yeah. And the court is broke.
Keeping them where they are. And every single year at the Assembly of State Party, there's this discussion over the budget, and that's the most painful part of it. And that also influences whether you're going to go for an international prosecution or if you're going to have local prosecution, if you're going to try to convince the country to ratify the Rome Statute so that the ICC can step in.
Yeah.
And I think in Sierra Leone, I mean, at least in the rural areas, I mean, there's almost no difference between having it be a hybrid court versus having it be, for the people who live in the rural
That's true.
areas, it's all foreign.
Exactly.
I mean,
I've heard that in other
they don't
contexts
really,
as
I
well.
mean, so I don't know about Cambodia, it sounds like maybe a little different, but in that case, I mean, I don't think it's qualitatively that different.
Yeah, the urban-rural divide is just as important
Huge.
as the local-international divide, because
shocking.
it's still elitist. Even in Rwanda, you know, in the Gacaca courts there's a big divide between elitists from Kigali coming in and telling people in local communities what to do in their Gacaca,
Right.
and they were as foreign to them as, you know, white observers that
Right.
were coming in,
Right,
so.
Well, then, I don't know how much you got into the details of each trial, but I know in the Lubanga trial, or I understand it was dismissed, the case was dismissed twice for prosecutorial misconduct. And of
Yes.
course, we know who the prosecutor was. But then reinstated on appeal,
Yeah.
his appeal, I assume,
Mhm.
and then eventually was successful. Do you know what the issues of prosecutorial misconduct were that led to that?
Lots. One of it was witness
They just like looked at
coaching.
each other like, oh god.
And then the other one was,
So witness tampering, I'm sorry, did you say that?
Yeah, it was more like, it was the use of intermediaries specifically, so who the ICC was using to get in touch with witnesses and get their evidence. The defense wanted that information disclosed, and because it's their right to know who was doing that, but the prosecutor said, if I'm getting this correctly, that would compromise their security and their anonymity agreements. But there's been concerns with trials since then that the ICC's intermediaries are coaching witnesses, and all that kind of stuff. So that was one of the problems with the Lubanga thing.
and the other one was the fact that the prosecutor was withholding disculpatory evidence
Yeah.
and refused to release it and didn't do it.
Yeah. And if I remember correctly too, in the Lubanga verdict, they were raked across the coals for their conduct. So even though it was a victory for the Lubanga conviction, the prosecutor's office did not come off well in the judge's statement. It was very interesting to watch that particular statement as well.
And that was the only prosecution in the 7 years of his
Yeah.
term, is that right?
Yeah. It's like, you won, but you didn't do a good job of it. It was essentially the lesson from the judges.
And I mean, I think that this specific, one of the two issues that came up, the one that concerned that non-disclosure of disculpatory evidence, I think it's really important, especially if we consider that the prosecutor has made so many statements concerning the ICC mandate and how that is supposed to be above and beyond. But then his mandatory obligation is to investigate both disculpatory evidence against and for the accused.
Yeah.
But it clearly,
Yeah, I mean, sometimes people just say, well, this is just the growing pains of the court, and, the rules have not been tested until the Lubanga case, and so that was, a bit of confusion for the judges and the prosecution, but I think in some of those cases, it was more clearly just prosecutorial misconduct, or whatever the word is, I don't know, but I'm not a lawyer.
Well, Alana, thank you so much.
Thank
This
you.
was